put it up there. Just ask,
She coming. I told her she's like.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person was convicted of a capital murder, the range of punishment, well, if a person was convicted of the lower offense, which is a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person was convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years, and a fine that does not exceed $10,000. Person is convicted of a second-degree felony. Range of punishment is minimum 2 years to maximum 20 years, and a fine that does not exceed $10,000. If a person was convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, your case is a misdemeanor case, so you don't have to worry about felony punishment. Misdemeanors are divided into 3 categories. We'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. That is, you cannot be given jail time. You only can be given a fine that does not exceed $500. However, if a person failed to pay the fine, or if they were given community service and they failed to perform the community service because the fine was converted to community service, if they fail to perform the community service, pay the fine, then the court can issue what is called a capias pro fine. That is a warrant for you to either pay the fine or sit the fine out in jail. You will be given $100 credit for every day that you sit in jail until the fine is paid off. Now, the next highest misdemeanor is a Class B misdemeanor. Range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine that does not exceed $4,000, or you could be given both such confinement and fine. Now, as a defendant in a criminal case, you have rights. And one of the rights that you have, we're going to talk about that, is your right to have an attorney. On the clipboard that you have before you, you should have a document on that clipboard that is titled Judge's Explanation of Rights to Defendants Without an Attorney. On that document, it states that you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. That is, you may give up your right to have an attorney to represent you, and you may represent yourself. When we say give up your right, you're waiving your right to have an attorney to represent you. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. If you want an attorney, but you do not have the money to hire an attorney, you would have to fill out a financial questionnaire. Financial questionnaire is the document on the clipboard that is titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page of that document and half of the second page, and the proper person will determine whether or not you qualify for a court-appointed attorney. Now, if you want to waive your right to an attorney, that is, you want to waive your right to an attorney, you want to represent yourself, you may speak to one of the two prosecutors that's sitting in front of you at the table. They are assistant criminal district attorneys that work with Jefferson County. They are commonly referred to as prosecutors. Now, you will have to, in order to speak to one of the prosecutors, you would have to first sign a written waiver of your right to be appointed or to represent yourself. Okay, so the written waiver is a document. It's the second document, or maybe the second document on that clipboard, that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I will go over that document with you in a few minutes. But continuing with the judge's explanation of rights of defense without an attorney, the next paragraph states, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, if you decide to waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Okay. Now, at the bottom of that document, in bold letters, it states, defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to ask for a court-appointed attorney, then you will put your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in this case, you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney or give up your right to have an attorney and you would like to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line at the bottom of that document that is titled defendant, and you will date it today's date, June 11th of 2024. Now, for those individuals who will be waiving their right to an attorney, that is, giving up the right to have an attorney to represent you like to represent yourself, you will have to sign the document on the clipboard. You're going to read it and sign it, and that document is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. And it states as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 11th day of June of 2024 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, June 11th of 2022. Excuse me, 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. In that area over there where those 12 chairs are, 6 citizens from Jefferson County will be selected to serve as jurors. They will sit in that area that we call the jury box. They will listen to all the evidence. They will listen to the arguments. They will deliberate, and then they will decide whether to find you not guilty or guilty of your charges. You also have a right to waive or give up your right to have a trial by jury. If you waive or give up your right to have a trial by jury, then your case will come before the judge or the court in one of 3 ways. One way it can come before the court is by way of a trial. We call that a bench trial. It's a trial by judge only, where the judge will be the judge and the jury in the case. Now, if you do not want a trial, either by jury or by judge, then your case can come before the judge by way of a plea bargain. Now, a person has the right to enter one of 3 pleas. They can enter a plea of not guilty. They enter a plea of not guilty. They're telling the court that they did not commit the offense that they've been charged with. Or they can enter a plea of guilty. If they enter a plea of guilty, they're telling the court that they committed the offense that they've been charged with. Or they can enter a plea of no contest, of nolo contendere, which means that they will not be fighting or they will not be contesting the charges. Now, if a person enters a plea of guilty or no contest, the case comes before the court by way of a plea bargain. And the second way it comes before the court is by way of an unagreed plea bargain. What an unagreed plea bargain is that you and the state have not been able to reach an agreement to settle your case. That's what an agreement is. Agreement to settle your case that you reach with the state is a plea bargain. Now, if you and the state are unable to reach a settlement on your case and you still want your case to come before the court, we call that an unagreed plea bargain. Now, it comes before the court or the judge, and the judge will decide what your punishment will be within the punishment range. Now, if you have an agreed plea bargain, in essence, you and the state have worked out an agreement to settle your case, then it comes before the court. The court can either accept or reject the plea bargain agreement. Now, if the court rejects the agreement that you made with the state, then you can take your plea back. For example, if you entered a plea of guilty to whatever your charge is, and you and the state have worked out a plea bargain agreement for you to do, let's say, probation and deferred probation. And the court, it comes before the court said, well, I'm not going to follow that agreement. Then you say, well, judge, I take back my plea of guilty or no contest. I'm not entering a plea of it. You have a right to do that if the judge does not follow the plea bargain agreement that you have agreed to with the state. All right. Now, the next thing is, if the judge follows the plea bargain agreement and you decide within 30 days that, you know what, I think I've been wrongfully convicted or the court has committed an error by convicting me, and I would like to appeal my case. And that's you like to have a higher court than this court to review the case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. Now, in order to appeal the case, if the judge goes along with the plea bargain agreement, you have to get the judge's permission. If the judge gives you permission, then your case is going to go from this court to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error. They can do one or two things. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. The case is over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, well, you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you would have to, you are representing yourself. You will not have the assistance of an attorney when you file the petition to the Texas Court of Criminal Appeals, and they can do one or two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, you also have a right to have witnesses to come to court to testify on your behalf or against you. We call that, and you can ask some questions if you're representing yourself, or if you have an attorney, your attorney can ask some questions. We call that either direct examination or cross-examination. You also have a right to waive your right to have witnesses. That is, you can give up your right to have witnesses. That means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I know some of us, we watch television, we hear people on a lot of these police shows, the guys say, I take the fifth. Well, what he's saying is, I'm not testifying, I'm not making any statements. You have a right to exercise your Fifth Amendment right against self-incrimination. That simply means that the state of Texas, the district attorney's office, or the government cannot force you to testify in your case. Now, you can waive or give up your Fifth Amendment right against self-incrimination, which means that you will be taking a witness stand. You also have a right to have what we call discovery. Discovery is you have a right to see the evidence that the state has against you. That is, you have a right to discover what the state has in its file. You have a right to see your statements, witness statements, police reports, lab reports. You have a right to listen to audio recordings, to view video recording, or whatever type instruments that they have. You have a right to have access to that evidence. You also have a right to waive or give up your right to have discovery. That is, you're saying, yeah, you want to have access to that evidence. Now, everyone that's here today for Raymond, you have been arrested and placed in jail, and you're out of jail on bond. You're either out on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a surety or a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance, which means that you were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time could be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail, and the state is offering you 5 days in jail as part of a plea bargain. That means that you won't have to do any more time in jail, because you will get credit for the time that you've already served. Now, if you spend 5 days in jail and the state is offering 7 days in jail, that means you will only have to spend 2 days in jail, because we'll take 5 from the 7 and that leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. You will be credited $100 for every day that you spent in jail that will go towards your fine and court costs. So, for example, if you spent 5 days in jail, that's $500 that can be credited towards your fine and court costs. Now, if they are offering fine and court costs of $700 and you only spent 5 days in jail, which is $500, that means you will only have to pay $200, because we'll take 500 from the 700, that leaves 200. Now, if you are unable to pay the fine and court costs. We can put you on a payment plan to pay it off. Now, if you can't pay it off because of your finances, we can convert the fine and court costs to community service. Now, for every 1 hour community service, you will receive $12.50 credit that will go toward payment of your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. If you've never been in trouble before, they will dismiss your case and you can get it wiped off your record. And the way it works, you'd have to get an attorney to help you fill out to make the application, to submit the application to the district attorney's office. It cannot be an offense involving unlawful arrest, resisting arrest, or unlawfully carrying a weapon. And it has to be your first time getting into trouble. Now, if you qualify, again, they will dismiss your case. And once you get in the program and complete it, you can get it expunged, which means erased, wiped off, or deleted from your criminal record. Now, if you are a veteran of any one of the military branches, Jefferson County District Attorney's Office also has a program that is called Veterans Court. It's for veterans only. And with that program is similar to the previous program that I just mentioned. You get into the program, complete the program, they will dismiss the case. And then you can get what is called a non-disclosure. What a non-disclosure is basically, it means that we cannot disclose the fact to the public that you had this case. The general public cannot have access to this. So your record is sealed to the general public. However, the government, police department and government, they can have access, but most of the public is general public, so they cannot have access to that record if you get a non-disclosure. Now, Jefferson County Court at Law number 2, which is this court, have a program that is called the CSI program, stands for Community Safety Initiative. That's a program that I started in March of 2017 within the first 100 days of taking office. With that program is designed to address the issue of what we call recidivism. Recidivism means that when people commit crimes over and over. And so to address the issue of recidivism, we have the CSI program, the Community Safety Initiative. With that program, we have partnership with various agencies in the Golden Triangle. One of the organizations that we have a partnership with is the Spindletop Center. The Spindletop Center is our local mental health center, and they have the ability to address your mental health needs. Now, what Spindletop will do, Spindletop will conduct private interviews. They will do an assessment. They can develop a treatment plan for either outpatient or inpatient treatment, depending on what your mental health needs are. Now, in order to get into that program, you do not have to be incompetent or insane to participate in the program. You could just merely suffer from depression or anxiety or any other host of mental illnesses. And they will address those issues. They also have a program that is called ATAR. ATAR it stands for Alcohol Treatment and Recovery Program. And with that program, they are able to address any alcohol or drug issues that you may have. We also have the same partnership with OZAR, which stands for Outreach, Screening, Assessment, and Referral. Is through our local drug and alcohol council. Those programs are alcohol and drug counseling programs. They have the ability to do a screening, an assessment, and also referrals. Now, also we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once a person is trained in one of those areas, then any of the areas that they choose, then they will assist them in getting a job in the area that they're trained in. Now, if a person have not graduated from high school and they would like to get their graduate equivalency diploma, which is a GED, then they also have a GED program. Now, all of these programs that I just mentioned to you does not cost you anything. They're free. Only thing it will cost you is time. And I like to say in this court, we don't just give time, we take out time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I always say that when you come to county court at law number 2, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in these programs, just let us know. And the other benefit about the program is that all of these programs can be used as community service. So for example, let's say you were unable to pay your fine, and your fine was converted to community service. And let's say you were in job training, you're getting trained for a job. For every 1 hour you in the class being trained on a job, $12.50 will go toward payment of your fine and court costs. And then you have the 1 hour that goes toward community service, and also you're in the program. Or let's say you're in the program with Spindletop, and 1 hour you with Spindletop, $12.50 will go toward payment of your fine and court costs. And then you have the 1 hour that go toward your community service. So you're killing 3 birds with 1 stone. That is, you're in the program, you're getting community service hours, and you're paying your fine and court costs. And so if you're interested in those programs, just let us know. We have some brochures that we can give to you so that you can take advantage of the programs that we have here in County Court at Law number 2. Now, we have some members from, well, some individuals here who's sitting in the jury box. They are with Spindletop, and they're going to come to you and tell you more about the program that Spindletop has to offer. We have Deputy Hinton and Chris. You welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy license on the state commission here with the sheriff's department. Well, this is my coworker, Chris. Now, Chris is a qualified mental health professional in Spindletop. The reason we are both here this morning in this courtroom is because the judge cares about every single person before the bench. The judge has found, when statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation.
So this is not all things. You need things like anxiety, depression, right? Things we all deal with at some point in our lives. Basically, every single person does. There's a host of other issues that we can deal with that some of us do. There's a lot of really great community resources out there, right? They're wonderful, they're well funded, they are hard to find. Some of them are made to where even just figuring out the name for what it is like jumping through hoops. And that's kind of where we come in. We understand there's a lot of stuff that everyone's dealing with that we don't see. It's all hidden. I know you all made it here. You all worked to get here. And I'm sure there's other things in your life that you had to manage to get here to show up today. And we want to help.
So maybe this is your first time being in court. It could be your 10th time being in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We're going to share that need with us. The Chris will explain exactly how you can do that.
So whenever you guys came in, every single person should have been handed one of these, right? This is built as a baseline HIPAA consent form. The reason it is built this way is so you know that any information you put on this sheet is protected under state law, the same as your medical information. The only one who is going to see this or do anything with this is me. The only one who's going to contact you off of this in the manner of your choosing is me. If you have a way, if you have a time that works best for you, if you have a way you want to talk, you know what you want to talk about, please put it down, because the only one's going to be picking those up, no one's going to be doing anything when they stay with me. Now, on the sheet, we have, like, there's a list of resources, right? It's not limited to, if you have something else you need, we hand this out to everybody for a reason. Because it doesn't matter if you're a defendant or if you're a support, if you need information for yourself or somebody, whoever. It doesn't matter if it's from this area, we are a chat, we call it, and we like to do that. This is just, if you have something you're trying to find out more about, if you need to talk, or something's going on, it's a way for us to be there. On that, if there's something you need, please tell us, and we will work as hard for you as you do for yourself. This is not gonna be a robocall situation where I blow up anybody's phone. I will respond back as much as you respond to me. The important thing is that you have your contacts and that you have the ability to reach out. If there's something that you need information for, and that's okay. If you want to speak privately today, there is an option on the bottom. If the court moves fast and you are done and you don't want to wait around the clock, that's okay too. If you have a time you want me to call, I can call you today. This is built to work within y'all's lives because, and man, you all showed up. I'm sure there's plenty of names outside that were called there, not in this room. This is not a moment anybody prepared for. This is not a moment that anybody expects. But if we can make it into something productive outside or help in some way to alleviate some other stressor, then we want to try and make this positive as we can. Apologize, we have one little voice too. Make sound like a mother.
I have a flyer here that I want to give everyone before you leave for today. On the back, it tells you some of the advantages of actually participating. But on the front, it also has a 1-800 number. Should you ever find yourself in those places, you can call that number and get help immediately.
So what's important about that is it's actually the first resource we use. That number is actually almost statewide. I say homeless because we know that there's plenty of places you have this with real homeless. But the big thing about it is that we know that a lot of people come to Fort Injection County from nowhere close to here. We work with people as far as Oklahoma County resources or just being there to support. Again, one of the resources we have is Stone Top. We can get you information on whatever you need, but it's not really what we have. Now, that number, and I can almost say what, it's active 24/7. You can call it Christmas morning at 6 a.m. needing to talk to them about something going on immediately. It is a crisis number. They will pick up, they will be there, they will get you set up with the most affordable resource at that moment. If it's not a moment crisis though, you'll also have my number. The number that I reach out to you by, or the email I reach out to you by, whatever you prefer, strictly goes to me. It is my work contact.
So just shortly, the court is going to go into recess, and when it does, we'll be able to come out there, we'll visit with you, we'll pick up those documents. I'll be handing this out for everyone as well, and we'll answer any questions that you may have at the time. Thank you very much. Thank you, Your Honor.
All right. Thank you, Deputy Hinton Chris. Now, ladies and gentlemen, as Deputy Hinton mentioned, we're going to be going into recess in a few minutes, but before we go into recess, I need to give you some instructions. Now, there are 2 restrooms out in the hallway. So if you need to use the restroom, the men's restroom is in front of County Court at Law number 3. And the female restroom, or the women's restroom, is on the opposite side of the hall in front of the 172nd District Court. Now, we're going to pick up the information, those clipboards from you. If you need assistance with filling out any of the paperwork, we have our court personnel who's here, who will be happy and available to assist you. If you need help, you can just simply raise your hand. Now, as I mentioned earlier, you can use the restrooms. They're out in the hallway. Now, do not leave the courthouse. And the reason why I say that, because if you leave the courthouse and we call your name, if your name is called, you're not here, a warrant is going to be issued, your bond is going to be forfeited, and a warrant is going to be issued for your arrest. So it's going to take us a little time. I mean, we're picking up the paperwork from you, and once we pick up the paperwork, we'll call you up before the bench one at a time, and you're going to stand before the bench, and then once you finish here, you're going to have a seat, and then our court coordinator will tell you what you need to do. Okay? So at this time, the court is going to go into recess. And as I mentioned earlier, make sure that you fill out the paperwork properly. if it's an affidavit of injuries, you need to fill out the first page and half of the second page. And if you are waiving your right to an attorney, that is, if you are requesting that you represent yourself, then you will also have to fill out, read and sign the document that is titled waiver of counsel for purposes of entering guilty plea or proceeding to trial. And on the judge's explanation of rights to defendant, make sure you put your initials on one of the lines that applies to you, whether or not you want to hire an attorney, whether or not you already have an attorney, or whether or not you want to apply for a court-appointed attorney, or whether or not you already have a court-appointed attorney, or whether or not you like to waive your right to attorney and represent yourself. So again, make sure those documents are filled out. If you need assistance, just let us know, and we'll have our court personnel here to help you with filling out the paperwork. So at this time, the court will go into recess. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 24 CCCR 0744. Case is styled the state of Texas versus Jatame Holland. Mr. Holland, would you please come forward? Please stand in front of the bench. Mr. Holland, your full name is Jatame Holland. Mr. Holland, would you please raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Holland? That's good. And Mr. Holland, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled defendant?
yes, sir.
Or are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Holland, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Holland, your case is going to be reset to give you an opportunity to hire an attorney. Our court coordinator is going to give you a reset, but before she gives you a reset, I need to give you some bond conditions. The bailiff is going to hand you some bond conditions, and I'm going to go over these bond conditions with you. The title is Standard Bond Conditions in County Court at Law number 2. Do you see that title? Okay, and it reads as follows. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol. At any time is directed by the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3 and 4, well, condition number 3 does not apply. However, condition number 4 does apply because the offense that you've been charged with DWI second is a subsequent offense listed under chapter or section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states as follows: the defendant whose information charges any subsequent offense listed under section 4904 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense, with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, sir.
And condition number 5, the defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violations will be grounds for revocation. Do you understand that condition? And condition number 6 states that the defendant must attend AA/NA meetings 3 times a week and provide proof to the court. Do you understand that condition?
Yes.
Now, I have a document that I need to give to you. This document contains locations in Jefferson County where there are AA/NA meetings, and it's also, the bailiff will also give you a sign-in sheet that you will bring to AA meetings. When you go, they will sign to verify that you're there. You need to bring that back with you every time that you come to court so that we can verify that you are attending AA meetings. Do you understand?
Yes, sir.
Okay. Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? All right. Just have a seat in that first chair on the wall and wait for the court coordinator to call your name. Once she calls your name and you finish with her, you'll be free to go and you have a blessed day. Next case is cause number 24 CCCR 0760. Case is style of the state of Texas versus Stephen Johnson. Mr. Johnson, your full name is Stephen Johnson? Okay, Mr. Johnson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson?
Mm.
That's good, Mr. Johnson. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled defendant?
yes,
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
yes,
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
yes,
On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
yes,
And Mr. Johnson, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
yes,
Okay, Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you. You will also be given information to contact him. The court coordinator will give you that information, but before she gives you that information, he gives you some bond conditions. And Mr. Johnson, I'm going to go over these bond conditions with you. The document that just been handed to you is titled Standard Bond Conditions in County Court Law Number 2. Do you see that title? The title is Standard Bond Conditions in County Court Law Number 2. It's in bold letters.
yes,
Okay, I'm going to go over this document with you, and it reads as follows. Following the return of criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that
yes,
condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
yes,
And condition number 2, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
yes,
Now, condition number 4 does not apply. However, condition number 5 on the next page does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Want me to read it to you again?
yes, please,
It says the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Johnson, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
yes,
Okay, Mr. Johnson, you're gonna have a seat on that first chair on the wall. Wait for your name to be called. Once you finish with her at the window, then you're free to go and you have a blessed day. Next case is cause number 24CCCR 0756. Case is styled the state of Texas versus Mia Bevel. Ms. Bevel, is your full name Mia Bevel?
Yes,
Ms. Bevel, would you please raise your right hand? Ms. Bevel, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, sir.
Ms. Bevel, you may put your hand down. How are you doing, Ms. Bevel?
I'm okay.
That's good, Ms. Bevel. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line as title defendant?
Yes, sir.
At the top of this document, on a line that states, I would like to have my case, well, I'd like to apply for a court-appointed attorney.
Mhm.
Are these your initials?
Yes, sir.
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Ms. Bevel, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Bevel, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. But before she gives you the information, I need to give you some bond conditions. The bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
Okay, I'm going to go over this document with you, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a political subdivision. You understand that condition?
Yes, sir.
Okay. Now, Ms. Bevel, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Please have a seat in that chair and wait for your name to be called. Once you're finished with the court coordinator, you're free to go and you have a blessed day. Next case is cause number M327280, case of Style, State of Texas versus Albert Martinez. Ms. Martinez, your full name is Albert Martinez? Mr. Martinez, would you please raise your right hand? Mr. Martinez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Martinez, you may put your hand down. Mr. Martinez, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line as titled defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant's signature. Is this your signature? Mr. Martinez, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Martinez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in the chair. Next case is Travion Wiggins? Come forward, Mr. Wiggins. Mr. Wiggins, your full name is Travion Wiggins?
Yes, sir.
Mr. Wiggins, would you please raise your right hand? Mr. Wiggins, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Wiggins, you may put your hand down. How are you doing, Mr. Wiggins? That's good, Mr. Wiggins. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line? It's titled Defendant?
Yes, sir.
And all these your initials on the line state you'd like to apply for court appointed attorney. Now, Mr. Wiggins, I also have another document that's titled Jefferson County Affidavit of Indians. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Mr. Wiggins, before you signed and initialed these documents, did you read the documents?
Yes,
Did you
sir.
understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Wiggins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Reagan Minaldi. Attorney Minaldi will be given information to contact you. You will be given information to contact her, and our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that third chair. Troy Angel. That's two. Mr. Angel, your full name is Troy Joseph Angel. Mr. Angel, would you please raise your right hand? Mr. Angel, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Angel, you may put your hand down. How are you doing, Mr. Angel?
Good.
That's good, Mr. Angel. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to apply for court-appointed attorney? I have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Stand jail before you sign and initial these documents. Did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Angel, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that 5th chair on the wall. Louis Carroll. Okay. Mr. Carroll, your full name is Louis Manuel Carroll. Mr. Carroll, would you please raise your right hand? Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth so help you God? You may put your hand down. Mr. Carroll? Mr. Carroll, how are you doing? Okay. We hope that you recover from, you had a broken leg. We hope you have a speedy recovery. Now, Mr. Carroll, I have before me a document, or two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you like to, your initials say you like to waive your right to an attorney and represent yourself?
Well, I mean, that's because it's my first offense.
Okay, but I see I have a affidavit of indigence saying you want to apply for court appointed attorney. Okay, Miss, you need to get this document. He need to strike through the his initials on that, on the line that said he wanted to waive his right, he'll put his initials on the line, he'd send it to the court appointed attorney. You're gonna strike through the initials.
Oh, I thought you.
He has an affidavit of injuries right here.
No, I wouldn't. Learn from him.
Oh, I thought you wanted to talk to the DA. That's what you said. So you completed that one, that one?
Yeah,
All right.
Yeah.
Yeah. That's about it. And then you want to.
okay, now, Mr. Carroll. Again, I have before me, Judge, a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court appointed attorneys? I also have a document that is titled Jefferson County Affidavit of Indigence. And this, do you recognize this document? And is this your signature on the line that's titled Defendant Signature? Now, Mr. Carroll, before you sign and initial these documents, did you read the documents? Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Carroll read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court appointed attorney. The attorney that will be appointed to represent you in your case is Attorney Laurie Perazzo. Ms. Perazzo will be given information to contact you. You will also be given information to contact her. The court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that, on that first row chairs behind the wall.
Thank you.
You're welcome. Jonathan Levi. Mr. Levi, your full name is Jonathan D. Levi. Mr. Levi, would you please raise your right hand? Mr. Levi, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Levi, you may put your hand down. How are you doing, Mr. Levi? You all right? Okay. Well, we'll see if we can get you out of here so you can go back and get your rest. Now, go back to work. Okay. Now, Mr. Levi, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? You have to speak up.
Yes, sir.
Are these your initials on the line that state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Levi, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
You understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Levi, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in your case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will also be given information to contact her. The bailiff of the and our not for him. It's gonna be for the next guy.
Okay.
The court coordinator is gonna reset your case. Once she gives you that information to reset your case, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Next case is Brian Allen Boatner, cause number 24 CCCR 0722. Boatner, would you please come forward? Mr. Boatner, your full name is Brian Allen Boatner?
Yeah.
Mr. Boatner, would you please raise your right hand? Mr. Boatner, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Boatner, you may put your hand down. How are you doing, Mr. Boatner? You doing good? That's good. Now, Mr. Boatner, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? You have to speak up. Is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there is a signature above the line that's titled Defendant Signature. Is this your signature? Also, now, Mr. Bolton, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Yeah. Which means somewhat.
We didn't see.
Okay, what did you not understand? Okay, because on the first document, it told you your right to have an attorney. You had 3 options. You can hire an attorney, you can ask for a court-appointed attorney, or you can waive your right to attorney and represent yourself. You understood this document?
Yep.
The next document asks you about your financial information. You understood that too? Okay, the last page, it just asks for your name, address, and your signature. You understood everything? You signed? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Boltner, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information, but she's going to give you that information. Once you get the information from her, you'll be free to go. You have a blessed day, but before she gives you that information, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? Standard Bond Conditions in County Court at Law Number 2 in bold letters. Okay, I'm getting ready to go over this document with you, and it reads as follows. Following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol. And the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition? And condition number 3 and 4 does not apply. However, condition number 5 does apply. The defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by Section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now explain to me what's funny. When I went over these conditions about the gun, you started laughing. Okay, now if you possess a gun or a firearm or ammunition, your bond can be revoked. And if your bond is revoked, you'll be placed in the Jefferson County Jail. Do you understand that? And if you violate any one of these conditions, your bond can be revoked. You'll be placed in Jefferson County Jail. Okay? All right. Have a seat in the 3rd chair by the wall. Next case is cause number 24-CCCR-0754. Case is styled State of Texas versus Dallas Norris. We're gonna need Miss Jennifer. We're gonna get her next. Next case, cause number 24-CCCR-0754. Case is styled State of Texas versus Dallas Norris. Miss Norris, is that your full name?
Dallas Norris.
Okay, Ms. Norris, would you please raise your right hand? Ms. Norris, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Norris, you may put your hand down. How are you doing, Ms. Norris? You okay? Ms. Norris, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
On page 2 of this same document, there is a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir.
Ms. Norris, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
As far as I read your answers, based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that 5th chair on the wall.
Thank you.
We didn't have any pro ses. This kind of code number 2 is back in session. The code is in session. The cause number 24CCCR0192. Case is style and state of Texas versus Orinia Castro. Okay, this is Orinia Milagro Castro. It's my understanding that Ms. Castro speaks Spanish. We have Ms. Jennifer Raji, who is our Spanish interpreter. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret Spanish to English and English to Spanish, so help you God?
Yes, Judge.
You may put your hand down. How are you doing, Mr. Raji?
Good, Judge. Thank you for asking yourself.
I'm doing fine, thanks for asking. Now, Mr. Raji, ask Ms. Castro to raise her right hand, and she will, Ms. Castro, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Right. You may put your hand down. Ask Ms. Castro how she's doing.
Good.
She's doing good. That's good. Ms. Castro, I have before me a document.
Yeah, come back.
I can show these you can show these documents to her. Now, the first document is judge's explanation of rights to defendants without an attorney. Ask Ms. Castro, does she recognize that document?
Yes.
Ask her if that is her signature on the bottom of that document above the line that is titled defendant.
Yes, eso firmó aquí. Yes.
And ask her if those are her initials on the line that states you'd like to apply for court-appointed attorney.
Y esta su donación diciendo que quiere aplicar para un abogado.
Okay, now
Yes.
turn to the next document, Jefferson County Affidavit of Indigents. Ask if she recognized that document.
Because, esta forma.
And turn to the second page. At the top left hand, well, in the top left hand corner, there's a signature above the line that's titled defendant. Signature ask her if that's her signature.
Y esta su firmó aquí. Yes.
Okay, ask her now, before she signed and initialed these documents, Mr. Roger, did you go over these documents with her in Spanish?
Antes de firmar este documento, sí, pues, expliqué todo en español. Yes.
And did you understand everything in these documents?
Y también, que firmaste.
Now, is everything in these documents true and correct to the best of your knowledge?
Y todo en nuestros documentos de verdad. Yes.
Okay, Ms. Castro, I read your answers. You meet the eligibility requirements for the appointment of attorney. An attorney that will be appointed is Attorney Charles Ross.
Okay.
Okay, and now this will conclude your case. The court coordinator is gonna call her name and they're gonna reset her case. She will be given information to contact Mr. Rojas, and Mr. Rojas will be given information to contact her.
Okay. Okay.
Okay, and just tell her she can have a seat in that first chair on the first row of chairs behind the wall, and tell her to have a blessed day.
Okay.
Okay,
Do you want to start or?
she can sit. Okay, now the next case is cause number 24-CCCR-0796, case of style of state of Texas versus Christopher Joel Gonzalez. Christopher Gonzalez was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Christopher Gonzalez at the courthouse door. Christopher Gonzalez did not answer. A reasonable time has passed to give Mr. Gonzalez an opportunity to appear in court. The time now is 11:48 a.m. on today's date of June 11 of 2024. Ms. Bailiff, would you please call the name of Christopher Gonzalez at the courthouse door? Thank you, Mr. Raji.
Yes, I do.
Okay, Christopher Gonzalez's name was just called at the courthouse door. Christopher Gonzalez did not answer. Reasonable time has passed to give Mr. Gonzalez an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State Bruce for bond forfeiture.
That motion will be granted. Christopher Gonzalez's bond will be forfeited and warrants should be issued for his arrest in cause number 24-CCCR-0796. Next case is cause number 24-CCCR-0608. Case of style state of Texas versus Dante Dwayne Howe. Dante, and also he also has cause number 24-CCCR-0609. Both cases are style of state of Texas versus Dante Dwayne Howe. Dante Howe was scheduled to be in court this morning at, did he have a felony set for sentencing?
Would you like me to check real quick, Your Honor?
Yeah, it says set for sentence.
That today.
Which one is that?
Dante Howe. He's in custody too.
Yes.
You don't have to worry about that.
Yeah.
But if he got, we probably, if his case was disposed of,
I'll check.
we probably set him for tomorrow. Next case, well, the next guy, he's in custody too.
Yeah, it was just-
Hampton,
It was a female that then
he's in custody.
Tasia.
Okay, Vantasia Williams.
Yeah.
Fantasia Williams was scheduled to be in court, or Vantasia Williams was scheduled to be in court this morning at 9 a.m. For the court's arraignment docket at about 9 a.m. The court's be able to call the name of Vantasia Williams at the courthouse door. Vantasia Williams did not answer. Vantasia Williams has not appeared in court since the court has been in session. The time now is 11:51 a.m. on today's date, June 11, 2024. Ms. Bailey, could you please call the name of Vantasia Williams at the courthouse door?
Donovan,
Fantasia Williams. Fantasia Williams. First class yard.
Okay, Vantasia Williams' name was just called at the courthouse door. Vantasia Williams did not answer. Reasonable time has passed to give Ms. Williams the opportunity to appear in court. She has not appeared in court. State, you have a motion? That motion will be granted. Vantasia Williams' bond will be forfeited and a warrant should be issued for arrest and cause number 24CCCR0348. And this will conclude the calling of the arraignment docket on today's date of June 11, 2024 in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. The court will be in recess till 1:30 this afternoon.